i-express amendment na nagawa na po ng RA 9522 na i-amend siya impliedly. Pero hindi pa siya express. At dahil doon, may pagkamalabo pa po yung ating batas minsan. Next slide po. At next slide po, ang example po niyan, yung sa Treaty of Paris. Yung Treaty of Paris, ginawa po natin yon in 1955 dahil our very brilliant Filipino lawyers, kailangan po natin ng legal basis para i-treat ang Pilipinas as an archipelago. Ngunit pa noong 1950s, wala pa pong archipelagic theory sa international law. Kung kaya't ang ginawa ng Pilipinas, ginamit natin ang Treaty of Paris upang maging basehan natin ng waters. Pero kung tingnan niyo po yung original wording ng Treaty of Paris, islands lang. Pero ni-reinterpret po natin sa RA 3046 bilang waters para magkaroon po tayo ng basehan para sa archipelagic treatment. Dahil noon, wala tayong basehan. Noon yon. Ngunit sa UNCLOS, may basehan na po tayo pagkat ayon sa UNCLOS, meron po tayong karapatan na magkaroon ng archipelagic baselines bilang archipelago. Kung kaya ito, kumaga, ito kailangan natin noon at magaling ang abogate natin noon. Ngayon, may bago ng batas, kailangan nating ayusin ayon sa bagong batas. Next slide po. At isa pa pong legal reason why kailangan natin is dahil isinusumbat po sa atin ang napakatagal nating pag-comply. Makikita po nito sa statement po ng People's Republic nung inobject po niya yung jurisdiction ng tribunal sa 2016 arbitral ruling. Ang isinumbat niya yung tagal ng Pilipinas mag-comply. Pakikita niyo po sa paragraph 50, ang Pilipinas nga 2009 lang nag-comply. Bakit niyo kami pinapagalitan? Kung may isinusumbat po sa atin yung mga neighbors natin dahil matagal po tayong ayusin ang ating batas. Next slide po. At nasabi po natin, sinabi ng Presidente na kailangan po nating ipagtanggol ang ating maritime zones. Dahil po, trabaho po yan ng AFP at ng iba pang ahensya ng gobyerno. Next slide po. Ngayon po, pag naayos na natin, isa pa po, may political reason pala po bakit kailangan natin ang maritime zones bill. Dahil po, kung tayo po ay ipagtatanggol natin ang ating kasarinlan at i-uphold natin through law enforcement and others, kailangan po natin na may kakayahan tayo. At kung may limitasyon yung kakayahan natin, then kailangan natin ang suporta ng international community upang tulungan tayong ipagtanggol ang ating karapatan. Ngunit kung gusto natin ang support ng international community, kailangan ang batas natin tugma sa batas ng international community upang we're on the same page legally at meron po tayong diplomatic basis upang ma-secure ang kanilang support. Kumaga po, kung kailangan natin ng suporta nila dahil may kakayahan tayo pero limitado talaga kasi napakalawak ng dagat na kailangan nating ipagtanggol at ipatrol, kailangan na dapat tugma rin ang ating batas ayon sa batas pandaigdigan or UNCLOS. Next, ito po. Ngayon ang step 2, pag natapos na po natin yung maritime zones at nasa mandate rin po ng committee na ito, kailangan na po nating mag-enact ng archipelagic sea lanes law at mag-designate ng sea lanes and air routes. Bakit po? Next slide po. Dahil ayon sa UNCLOS, Article 42, which treats of international straits, pero ina-apply po kasi yan sa archipelagic sea lanes, ang bayan, coastal state, pwede po tayong magtalaga ng batas na umiiral sa mga barko o at may aeroplano na dumadaan sa sea lanes at overflight routes. At tayo, as coastal state, ang pwedeng mag-legislate niyan at that's sa Kongreso. At next slide po. At bakit kailangan mag-designate? Dahil kung hindi po tayo mag-designate, and then ang pwede na lang gamitin yung routes na normally na ginagamit sa international navigation. Whereas kung mag-designate tayo at i-negotiate natin sa International Maritime Organization at sa ibang maritime states kung ano yung acceptable designation, pwede na mo tating malimit kung saan pwedeng dumaan sa ASL passage. Next slide po. Now, third...
Stop there.
Yes, sir.
Magaling ka pala mag-Tagalog. Kala ko magtataglish ka eh. So, can I stop there? I happen to have a letter coming from one of the resource persons here who was supposed to be here, Professor Robert Beckman, ang sabi niya, if I Englishin, basahin ko muna yung tapos translate ko sa'yo, pero magaling ka mag-Tagalog. And I quote him, as I understand, the recommended practice is that the archipelagic state should first consult with major users, for example, Australia, United States, etc., to try to reach an agreement on the routes normally used for international navigation through the Philippine archipelago. The archipelagic state should then make a proposal to the IMO, I suppose this is the International Maritime Organization, for the designation of the archipelagic sea lanes. Once the proposal is approved by the IMO will then designate the sea lanes. The archipelagic state will then enact the necessary domestic legislation, unquote. So, is this the proper way? Sila muna yung mag-approve tapos saka pa lang kami gagawa ng batas? Isn't this a delusion of Philippine sovereignty?
No.
There is another explanation here, and if I may quote, the Philippines should learn from this experience. My concern, coming from Professor Beckman, this is Professor Beckman, my concern has been that some of the bills that have been introduced in the Philippines, in your parliament, probably referring to the Senate, seem to suggest that the Philippines can declare archipelagic sea lanes unilaterally without proposing the adoption of sea lanes by the IMO. This is not consistent with the 1982 UNCLOS or the practice of the IMO. If national legislation declaring archipelagic sea lanes is enacted before the Philippines proposes sea lanes to the IMO, the Philippine proposal is likely to be met with serious resistance from interested states at the IMO and not approved. This would then require the Philippines to amend its legislation so that it is consistent with the lanes approved by the IMO. Bakit ganito? Mauna pa sila mag-approve kaysa sa Senado? Bakit po gano'n? Pakiliwanag po yun. Medyo naguluhan ako doon. Siguro yung sagot nyo, pwede English, pwede Tagalog.
Salamat po. Thank you very much po. Kasi po, nakalagay po kasi sa UNCLOS is that ang states will designate their archipelagic sea lanes after due consultation with a relevant international body. Ang relevant, nakalagay, hindi nakalagay pong IMO, nakalagay relevant international body or competent international body. And ang ano po niyan would be IMO yung identified. Yun po yung procedure na sinunod po ng Indonesia, which is the other large archipelagic state in this area, na nag-consult muna sila and thereafter. At hindi, yan po nga po, yan tama po, sir, and I fully defer to Professor Beckman on this point, yan po yung tamang procedure, and if I may po, consistent po yan sa ating kasalinlan.
May we ask the opinion of Professor Gregory Polling on this matter? Otherwise, we will be constrained to invite the IMO during our hearings for the archipelagic sea lanes. Professor Polling, any views on this? Contrary or otherwise?
I would defer to both Attorney Neal and Professor Beckman, who are actually trained lawyers. I am not.
So, in effect, consult first with the IMO before approving an ASL. I'm jumping the gun because we're still tackling the maritime zone law, not the ASL.
That would be ideal, Your Honor. If I may, actually, there is actually, Your Honor, there is language, for example, in the Blue Economy Bill, filed in the House of Representatives, which is actually consistent with that. I think Section 28, I'm not sure, of the Blue Economy Bill actually provides, empowers the council, there.
I'd like to acknowledge the arrival and presence of Senator J.B. Ejercito, our Deputy Majority Leader. Good afternoon, sir. Go ahead.
There's actually procedure there which does not designate any... Yes, sir. Yes, sir. The language of that one actually does not designate any lanes, but rather authorizes the executive to negotiate and thereafter designate. Kumbaga po, yun po yung language na finalo po sa Blue Economy Bill, I think Section 28, which stated that the executive, in that case the council under the executive there, is hereby empowered to negotiate with the relevant international organization and then to establish archipelagic sea lanes. That would
that will be after the fact. So what what the Blue Economy Bill envisions to happen is that craft a general law and then authorize the president to negotiate with the IMO and then go back to Congress again to legislate the archipelagic sea lane. Is that the process?
Your Honor, insofar as that is concerned, that is at least that is the process enshrined in the bill, and it does not require that the executive go back to Congress, because the moment the Congress has already deputized and delegated to the president the authority to make the bills, it will already be consistent with the power of the president as executor of the laws to negotiate and thereafter to designate and establish the sea lanes. This is in fact relevant, and actually, if I may, it's relevant to note that this is consistent with the administrative power of the president, because there are already sufficient standards provided in such a law. And
That would need
also,
delegation.
yes, sir. Yes, sir. So would
What
be a
about
valid
the
delegation.
air routes? Yung sa aeroplano? Kailangan din ba sino naman ang kamiting namin para doon sa international, IATA? Sino ang magde-designate nung sa airspace? Sino magde-designate nun? Following that line of thinking.
I have to study it further, but I think it's ICAO, Your Honor. The International Civil
Is there a
Aviation
need likewise to consult first with the ICAO before designating an air route?
Your Honor, I am not certain as to this point. I have to study it again, but I would defer to the CAAP and to the relevant
Kasi
agencies.
that's your step 3. Enact an archipelagic sea lane and designate sea lanes
Yes, Your
and
Honor.
air routes.
Yes, Your Honor.
Oh, so ganun din sa air routes, makipag-usap muna sa ibang international organization bago kami gumawa ng batas?
Yes po, but as to the exact procedure, I must confess, Your Honor, that I am not fully cognizant of the exact procedure. But perhaps the DFA could.
DFA, can you help us since you're the expert also?
Yes, about the archipelagic.
Yeah, there's a question here, Senator Gatchalian. Consult or negotiate? Iba yung consult. Consult, pwede sa virtual lang. Negotiate, luluwas na kami ng France niyan.
It's Your Honors, it's a consultative process with the IMO about the archipelagic sea lanes passage, or the archipelagic sea lanes. The idea in the task force meetings is that the bill should empower the president to designate or substitute or add more archipelagic sea lanes depending on the circumstances. So the final law does not indicate the coordinates of the sea lanes. It describes them, and then the president, based on the discussions with IMO and with user states, will be able to designate the final archipelagic sea lanes by executive order. That is the idea of that is how we in the task force believe it. Your Honor, also.
But nothing prevents Congress from designating the sea lane with the meets and with the proper coordinates. NAMREA is here, so
We will not certainly stop the Congress from doing so. And of course, but we'd like some flexibility in the final version so that if necessary, the President could amend the sea lanes depending on
but
the
Congress
reaction by IMO.
can limit the number of sea lanes.
Well,
For
yeah.
instance, if it's 3, tatlo
Yes.
lang yung dadaanan.
Yes.
The president cannot make it 4 or 5.
Yes.
Diba? But the president can negotiate kung dadaan ng Palawan Strait, dadaan ng Babuyan Island,
Yes,
Cebu
indeed.
Sea,
Yes.
Sulu Sea.
Opo.
Okay, the same is true with air routes.
There were no
Archipelagic sea lanes are
Air, sa taas.
archipelagic sea. They include the air as far
No.
as we know.
Can you show,
But we'll
can
have
you
to
show
ask the
step 3?
experts here.
Attorney Silva, di ba sabi mo yung air routes, bukod, designate sea lanes and air routes. Air, kasi you quoted a provision here.
Yes, that's actually because UNCLOS actually provides for air sea lanes and air routes insofar as archipelagic sea lanes passage and overflight is concerned.
So yung eroplano, not necessarily doon sa designated sea lane lilipad, di ba? Kahit pwedeng iba.
It depends on what is discussed between the Philippines and the international community, Your Honor.
So kailangan din discuss, consult, or negotiate? Pareho yan? Or
Consult.
abide by their wishes?
It would be an act, Your Honor, of consultation and negotiation. Your Honor.
Consultation.
Yes, Your Honor.
So go ahead with your presentation, Attorney Silva.
Thank you, Your Honor. Thank you very much, Your Honor. And as I noted earlier po, batas, lakas at tikas po. Ang parallel po to all those steps is lakas. Kailangan po nating mag-build up po ng ating lakas dahil po makikita po niyo yung chart natin hanggang 2018, we have one of the lowest expenditure rates vis-a-vis defense expenditure to GDP rates in Southeast Asia in the region. Hindi po natin napagtuunan ng pansin ang ating kakayahan na ipagtanggol at i-monitor ang ating mga kalagatan. Napakalawak pa naman ng kalagatan yan. Sabi ko nga po, magandang nasa batas po tayo. Pero parallel to that, kinakailangan po natin na i-build up ang ating kakayahan na ipatrol at i-monitor ang ating dagat. Batas at lakas. At pangatlo po is tikas. At madadaanan po natin in the next part of the presentation. Next slide po. So, ito po yung part 2. Kung may time pa po yung committee or we can discuss in another time po.
Muna, kasi ito yung mainit ngayon eh.
Sige po. Okay. Ang part 2 po is...
Bakit mapula yan? Mapula yung isang kulay.
Dahil po nasa original source material po, ganun po
Okay.
talaga. Okay, next part po is paano po ito makakatulong sa ating diplomatic issues sa South China Sea. Clarify po lang po natin yung terminology na ang South China Sea is yan pong buong lahat ng dagat na yan sa kalagitnaan po ng Vietnam at ng China at ng Pilipinas at Indonesia at Malaysia. Next slide po. Ang West Philippine Sea, hindi po yung buong South China Sea, kundi yung parte lamang na nasa jurisdiction ng Pilipinas. Under AO29 issued by then President Aquino. Next slide po.
Can Congress change the name of West Philippine Sea to encompass a greater West Philippine Sea?
If I may, Your Honor, any such act, it is within the jurisdiction of the Congress. However, if it's a greater West Philippine Sea encompassing the entire South China Sea, it may have diplomatic ramifications, and for that, I defer to the Department of Foreign Affairs on whether that would be diplomatically advisable.
Ano to, parang yung Greater Manila area, di ba? Dati Manila, Greater Metro Manila, Greater, meron pa nga Mega Manila eh. So ito, Greater West Philippine Sea. Pwede ba yun, sir? Yes or no lang mo? Sir, no?
We're not going to say hindi pwede, sir. Except
Yung ba sagot natin sa 10-dash line?
except internationally, the term might not be recognized. Like for example, West Philippine Sea does not appear in foreign maps, the term West Philippine Sea. But internally, we can say it's the greater
Greater West Philippine Sea.
It sounds good.
Pinakain ka na ba? O bigyan pa natin ng merienda si Yusek.
Hindi, pero kasi yung Philippine Sea, yung sa kanan eh. So ito yung West Philippine Sea.
Sea.
Kasi kung Greater Philippine Sea, that might,
West Philippine Sea.
well,
Depends how far.
depends on how far, sir. As long as it doesn't say that the sea is Philippine territory, kasi that would be a violation of UNCLOS itself.
Greater.
It sounds good.
So gaya nung Greater, yung Metro Manila lang. But Greater Metro Manila area can encompass San Jose del Monte, Bulacan, Bacoor, Cavite, Antipolo, etc. etc. Okay ka doon?
Opo, well, the only situation is the world maps or other countries will not use that term. They might not be offended by it. I know one country which should be offended by it. We know one country, large country, which should be offended by the term.
Pero kung okay ka na, ikaw na ang spokesman doon. Ikaw na magpapaliwanag.
But I like the term, sir. Greater Philippine Sea sounds good.
Sounds great.
Sounds great.
Thank you. At Attorney Silva, you may proceed.
Your Honors. Okay, to clarify po, sa South China Sea, may 3 pong klaseng hidwaan or dispute, na hindi naman away, dispute na hindi pagkakaunawaan. 3 klase po yan. Unang-una po, mayroon po tayong dispute ukol sa lupa. Recall po natin yung pinag-usapan natin kanina ng lupa, you occupy it at makukuha mo yung dagat around it. Ito po may dispute po sa lupa. Kasama na po dyan yung dispute ng Scarborough Shoal at ng Spratlys. Next slide po. Pangalawa po, meron po tayong overlaps ng mga dagat natin, ng mga maritime zones measured according to UNCLOS.
Michael, can we enlarge this? Paano ba
Actually, hindi, if I may say, hindi ko po, this is full at, for purpose of attribution, this is actually a map from Professor Beckman himself, and I hope he doesn't mind, with attribution. This is ano po, it's a map detailing from his publication concerning how the overlaps. Kasi po, when you draw 200, minsan babangga sa 200 ng ibang bayan, kailangan nyo pong mag-negotiate. Nakalagay po yan sa Article 74 tungkol sa EEZ ng kung mag-overlap ang EEZ. Tapos kung magbanggaan po or mag-overlap ang continental shelf, ini-negotiate rin po yan under Article 83 of UNCLOS. At nakalagay po rin yan sa ating batas po sa PD 1599, Section, I think, 2 or 3. I can't recall. Basta Section 2 or 3 na kung may overlap, ini-negotiate po sa ibang bayan. So, kasama po kasarinlan natin na makipag-negotiate talaga tayo sa ibang bayan. Next slide po is ang pangatlo pong klaseng hidwaan or di pagkakaunawaan ay yung effect ng tinatawag na 9-dash line ng ngayon 10-dash line. Yan po ay hindi po yan sang-ayon sa UNCLOS dahil ang pinagbabasihan po niyan is a distinct theory of law na pinupush ng People's Republic of China based on an earlier theory of law, pre-UNCLOS, nung labo-labo pa po yung batas. Next slide po. Ang pinanggalingan po niyan ay yung original line. Kung makita nyo po yung original label po niyan, nakikita naman po yung original label in Chinese sa may translation is islands. Mapa lang dapat siya ng islands. Ngunit, ngayon, parang although hindi klaro kung ano talagang ibig sabihin ngayon, sa 2009 note verbal ng People's Republic, nakalagay po doon, the People's Republic has sovereignty over islands and relevant waters. So hindi natin sigurado kung ang ibig sabihin ng relevant waters hanggang yung kabuuan ng line na yan. Pero mukhang yun nga po ang lumalabas, kung kaya po kinakriticize siya ng ibang bayan, katulad na po ng Estados Unidos na naglabas ng, I think, limits in the seas, I think 145, at recently, limits in the seas 150, pinapatunayan kung bakit hindi siya sang-ayon sa batas pandaigdigan or international law. Next slide po.
Can you provide, Attorney, a copy of those two? Is that a federal
Yes, sir.
law?
Yes, sir.
Provide-
Those are, yes, sir. The State Department study as limits in the seas, I think 145
Can you
and
provide us a
150.
copy?
Yes, sir.
Thank you.
Ano pong kaya po nag-file tayo ng arbitration proceeding under the leadership of the DFA and the OSG in order to settle ang legal issues. At sinettle nga po ng arbitration award, gaya nga po ng nasabi po ni Honorable Senator Padilla earlier, na settle po ng 2016 award. At ayun nga po, as summarized by the Honorable Senator Padilla, it was noted, sabi nga po, na sa atin na talaga yan, na-settle niya, na tayo ang may karapatan dyan. Na binding na po yan sa Pilipinas at sa China. Sa ibang bayan, hindi siya directly binding. Pero pwede po nilang gamiting modelo sa paggagawa ng mga policy nila. Dahil ayon po sa Vienna Convention on the Law of Treaties, at pwede pong sundin ang ginagawa ng ibang estado ang subsequent practice, at ayon din sa Article 38 ng Statute of the International Court of Justice, ang mga ruling ng mga korte at tribunal maaring gamiting source or secondary source or subsidiary source of international law. Kumaga, material source of international law po yun. So pwede po nilang gamitin yan. At pangalawa, at napaka-importante, pwede nilang tulungan tayo to persuade China to negotiate on the implementation of the award. Because yan po talaga ang panghihinatnan, makikipag-negotiate tayo. Ang gusto natin, ang kailangan natin, makipag-negotiate sila in good faith, batay sa award. Na ngayon, hindi pa nila ni-recognize. Although isinaad na po ni President Duterte in August 2019, nung pumunta siyang Beijing, sinabi niya, I am affirming the award. Ang sabi po ng Presidente ng China, I do not recognize it. Tapos na po bang ang usapan? Hindi po. Dahil sabi nga po ni Ambassador Chito Santo Romana, this is the beginning of a process. At ang parte ng proseso, batas, lakas, at tikas, at defense posture po yan. Next slide po. Ngayon po, yan po ang epekto niyan. Yung dating pink, yan po yung kiniklaim dati ng China. Mapa ito, hindi po sa atin to, map ito ng tribunal award. Yung dating pink, yan po yung kiniklaim dati ng China based on the maritime interpretation of the 9-dash line. Sinabi po ng arbitral award, hindi po sa kanila yan, dapat sa coastal state yan, sa atin, klaro na po na yung pink, except yung mga white dots of territorial sea, klaro na tayo ang may jurisdiction. Tayong may kasarinlan at karapatan, karapatan ay sa dagat pong yan. Next slide po. Kung kaya't isinaad po ng ating Pangulo noon, si President Duterte, sa hindi lamang sa isang bayan, sinabi niya sa China noong 2019. Ngayon, sinabi niya sa buong sandaigdigan po sa General Assembly na ang Pilipinas ay founded on UNCLOS at ina-affirm po natin ang 2016 award at wala nang magagawa upang matanggal ang award na yan. Nasa batas na yan, nakataga na po yan sa bato. Next slide po. So ano po ang way forward po natin? Ang way forward natin sa disputes natin, yung unang dispute sa China, pero dispute na may mga overlaps tayo sa ibang bayan po kasi. Ang overlap natin, ang way forward po natin, may legal at may political and physical aspect. Yung legal na aspect is kailangan nating i-implement ang ating karapatan kasi settled na po yan sa batas. Pangalawa, kung may overlap sa ibang mga bayan, ayon sa UNCLOS, kinakailangan nating makipag-negotiate under Article 74 and 83 of UNCLOS. In fact, sir, nagawa na po yan ng DFA regarding sa Indonesia. Meron po tayong overlap sa EEZ natin sa Celebes Sea, in fact, or Sulawesi, and ninegotiate po natin yung EEZ boundary natin with Indonesia, which was concurred in by the Senate in 2019. Kulang na lang po yung continental shelf, in-negotiate natin sa kanila, negotiation. At pangatlo, insofar as China is concerned, sa hidwaan natin, ang next step is makipag-negotiate sa China at i-persuade China to negotiate with us in good faith based on the award. Yun po. Negotiate in good faith based on the law, UNCLOS, and the 2016 award. Yun ang kailangan nating end state. Ang kailangan po niyan sa external legal steps is an internal legal step. I-clarify natin ang Maritime Zones Law. Bakit? Kung makikipag-negotiate tayo sa ibang bayan, Vietnam, or Indonesia, or China, kinakailangan yung legal basis natin klaro internally. Paano tayo makikipag-negotiate sa ibang bayan kung tayo mismo hindi tayo sigurado kung ano talaga ang boundary natin? Kumaga, tanungin tayo, saan ba talaga kayo ang gusto nyo? Eh hindi natin alam ang gusto natin, ano ang negotiation natin? Ngayon, parallel to that, we need physical and political steps. Externally, we need to assert physically our sovereignty through appropriate patrols by the Coast Guard and the armed forces of the Philippines Navy, and also because ang problema po kasi napakalawak ng dagat na nasa atin at limited talaga ang capacity natin to monitor yung buong yan. Kung kaya't kailangan natin ng suporta ng sandaigdigan at para makuha natin suporta, ang internal step na kailangan natin is Maritime Zones Law rin upang yung batas natin consistent sa batas ng buong daigdig. Kumbaga, makuha natin suporta nila, pero dapat ang batas natin sang-ayon din sa batas ng buong daigdig. At finally, internal political step, sabi nga po ni Presidente po, sa kanyang talumpati sa SONA, at sinasabi din po natin sa ating national security policy, kailangan po ng social cohesion. Kasama na rin po ang social cohesion ukol sa ating kasarinlan. At ang pinakamagandang step upang makuha ang internal at social cohesion na yan ay dapat wala na tayong disagreement tungkol sa ating boundaries. Kung kaya't, yung step 2 po na Maritime Zones Law, makakabuti po yan sa ating political steps upang makipag-negotiate tayo in good faith with other countries at sila makipag-negotiate sa atin. Ngayon, hindi po natin kontrolado ang behavior ng China. Posibleng mag-no pa rin sila at mag-no pa rin sila at mag-no pa rin sila. Sa kanila na po yon. Tayo po bilang bayan na may kasarinlan as a sovereign state, sa atin, our step is, handa kayo pag mag-negotiate in good faith, gusto namin makipag-negotiate at may batayan na kami. At yan pong batayan ay ang ating Maritime Zones Law at ang UNCLOS na nasa batasan daigdigan. Next slide po. At kung nga po, sabi nga po ni Presidente, kinakailangan na ipagtanggol natin ang ating bayan at ipagtanggol natin ang pagkakaisa ng ating bayan or social cohesion at ang ating kasarinlan. Next step po. Next slide. At yun na po ang huling slide. So salamat po. Thank you very much. I'll be happy to answer your questions, Your Honor.
Thank you, Attorney Silva. Unless Senator JB Arceto has an introductory statement to make. You have the floor, sir.
Thank you, Mr. Chair. Anyway, I'm here to listen also. And then I just probably if I can ask a question, given the current situation, siguro attorney can answer. Total kayo na rin po on deck. Given the current circumstances that we're in right now, given the hostilities in the recent months, no, how important is it to have our own, especially we're in the budget season right now, we are supportive, I guess everybody here is very supportive of improving, strengthening our assets, especially in our Navy, Coast Guard. How important is it on our part for us to be able to put up that credible defense posturing in this dispute, in this current situation?
If I may, Your Honors, I can only talk on the generalities of that, the fact that it is important because as a coastal state, we have both a right and a responsibility to implement applicable international law as well as Philippine laws in accordance with international law in those areas. But as to the particulars of why it is necessary to have the posture, I would defer po to the line agencies because that falls within their legal mandates to safeguard our sovereignty. I can only add in general na sabi nga po, law, strength, and posture or strategy na lang po, batas lakas tikas, because then we would have a clear set of steps and a clear capability to implement our laws. But that's a legal perspective. I would defer po to the line agency, sir, on the particulars of why it is important to have support for that in the West Philippine Sea. Thank you, Your Honors.
Thank you, Senator Estrada.
Also, follow up na lang before the line agencies can answer, particular DND or Coast Guard. Definitely, we are no match against China. So China is a superpower, no. But by improving our own assets, we don't have any intention of matching their military might. But I guess, Mr. Chair, Vietnam, although a small country, no, yung Vietnam, kahit nung panahon ng Vietnam War, maliliit sila pero pumapalag talaga, even now, no. I would having a respectable naval or Coast Guard assets be helpful in this situation right now? Kumbaga parang hindi naman pwede yung binubuli na lang tayo lagi. I guess we have to stand up and defend our territory. Kumbaga yung that posture is saying that we are defending our sovereignty.
In that case, Your Honor, I would defer to the expert writings of two writers on that point. Number one would be Professor D.P. O'Connell, who wrote on law and naval power. I think that's the title, where he noted that sometimes po ang mga bayan they don't necessarily fight each other directly. Rather, they use intimidation. Ang example na ginamit po niya nung time ng Spanish Civil War, nung may yung isang nationalist Spanish vessel was intimidated by a British vessel. It was not attacked, but because the British vessel demonstrated capability, and number two, it demonstrated willingness, lakas at tikas, willingness to act, therefore the vessel backed down. So it's not necessarily the ability to overcome by force, but it's rather the ability to project the willingness and ability to enforce your rights. And it's not necessarily war, but also law enforcement. Kasi kung law enforcement, kumaga po kahit I think the members of law enforcement can agree, you don't always fight the criminals. Sometimes the willingness and the ability to arrest them if they resist is all that is required. Because sabi nga sa law enforcement, there is a continuum of force concept. It doesn't necessarily go to lethal force. You can control through less armed and less forcible measures first, and you can succeed if you have the capability. And the second expert po is Corbett, who noted that in order to control the water, you need a fleet in being. Kumbaga po. Kumbaga, kung wala kang barko, hindi mo makokontrol yung tubig, basically po. But if you have the fleet in being to control the waters in the area, then you would be able, therefore, to dominate the sea lanes. And that is part of our right and duty as a coastal state, to patrol that. And last expert po is the CSIS, which has published many writings concerning gray zone coercion and gray zone competition, where they noted that in gray zone coercion po, yung gray zone, they don't use force. Other side doesn't use force, but it uses superior force and capability to intimidate and coerce a country by showing willingness and not willingness, but showing the capacity to force you. So that is how to counteract that, we would also need our own strength. But again, as to the details, Your Honors, I would defer to the armed forces and to the DFA. Thank you, Your Honors.
Senator Padilla has a question, but before that, I'd like to call the attention of my good friend here, Yusek de Vega. There is such an area in the southern coast of Australia called the Great Australian Bight. Bight is another word for bay. So ginagamit talaga yung Great Australian Bight. Para may reference ka rin kasi sumangayong ka na kanina eh. Senator Padilla, you have the floor.
Maraming salamat po. Balik ko lamang po kay Sir. Sir, opo. Kanina po kasi sa presentation ninyo, opo, katotohanan po ay sa page 32. Page 32. Baka pwede
Can
po.
we have that slide again, technical? The previous slide,
Pakilagay po sa page 32. Yan. Ito na. Bilang tayo po ay meron pang usapin ng dispute sa Sabah, gusto ko lamang pong malaman kung paano po ang magiging maritime zone dyan. Kasi wala naman po sa batas na binago tayo sa ating claim. Katunayan po dito po sa Section 2 ng Republic Act number 5446. Malinaw po rito na ang North Borneo ay kinikilalang teritoryo ng Pilipinas. Hindi naman po ito inamendehan noong RA 9522. Gusto ko lamang pong malinawan kasi dito po sa mapa po ninyo, dito sa page 32.
page 32.
Opo, nakalagay po talaga dito, disputed territory. Pagdating po dito.
Yung page technical, yung China's maximum potential entitlements.
Total, pinag-uusapan po natin yung mga pinagtatalunan, mga teritoryo. Siyempre po, bilang ako po ay Muslim senator, kailangan po ding maipaliwanag ko po itong gagawin nating maritime zone sa ating pong mga kapatiran sa Sulu. Gusto ko lamang pong maliwanagan kung paano po ang hatian nito o paano po. Maraming salamat po.
Thank you very much, Your Honor. First of all, without prejudice po, I defer po to the relevant agencies on this point. I can only have an abstract academic lang po na abstract idea in that particular, as noted, thank you very much, sir, Your Honors, tama nga po. So the Public Act 5446, inaffirm po ng Section 2 na hindi po na yung baselines po, hindi po apektado yung baselines ng North Borneo or Sabah over which the Philippines, ang nakalagay po is over which the Philippines has acquired dominion and sovereignty. Kaya nga po, in fact sir, if I may po, actually kaya po yung pagkaka-wording po ng Republic Act 9522 under then President Arroyo was very specific. Hindi niya po ni-repeal yung 5446. At hindi niya ni-repeal yung RA 3046. Ang binago lang po niya yung Section 1 na baselines ng archipelago. Kumbaga po, yung Section 2 po ng 5446, hindi po siya tinouch ng Republic Act 9522 upang nga po mapangalagaan at masecure pa din po yung kasarinlan ng Pilipinas ukol sa North Borneo na inassert po natin internationally also through the Republic Act 5446 as well as through the Republic Act RA 629. Kasi inaffirm po natin, sabi nga tama kayo sir, bakit ano pong mangyari nito? Hindi po siya tinouch ng RA 9522 at to my knowledge po wala pa pong batas enacting the maritime zones of that particular place. So I defer to Your Honor.
Perhaps the senior state counsel from the Department of Justice can add something here to the conversation here about North Borneo, Sabah, concerning the query of Senator Padilla.
Thank you so much, Mr. Chair, Your Honor, and good afternoon to you and to all the honorable members of the Special Committee on Maritime and Admiralty
You
Law.
have yet to take your oath, right?
Yes.
Can you
I
please
did.
rise and raise your right hand?
I took my oath already.
Tapos na? Okay.
Yes,
Go ahead,
Mr.
go
Chair.
ahead.
And I will relay to the Secretary your request that in the next hearings, maybe he might attend, but I'm authorized to appear here. Mr. Chair, under Secretary Remulla, I've been with the DOJ for quite some time, and I was the handling focal lawyer for maritime issues since 2009. But under the Secretary and through the suggestion of Yusek Vasquez, our Yusek for Legal, he created the DOJ Legal Staff Maritime Group, and I'm the head of that group, Mr. Chair. With respect
Can
to...
you answer the question?
Yes, with respect to the issue of Sabah, this is clearly a territorial issue, Mr. Chair. But of course, under our laws, we consider Sabah, North Borneo, not Sabah. We consider North Borneo as part of our national territory under Article 1 of our Constitution. And with respect to the question of Sen. Padilla, what is the maritime zone? Yun po yung tanong ninyo, di po ba? Ano po yung maritime zone ng North Borneo? That's correct kasi Mr. Chair, if you, and thank you to the presentation by Imblos, the DOJ agrees with all of the legal things stated there. Kasi po, when nakita ninyo na yung archipelago natin, Suman Archipelago may sarili siyang zones, maritime zones. Pero hindi po kasama dun yung North Borneo, di po ba? Kasi yung maritime zone po ng North Borneo, hindi po siya measured from the archipelagic baselines. Hindi po kasi kasama yung North Borneo sa main archipelago natin. Pero hindi po ibig sabihin that under Article 1 of our Constitution, na hindi siya kasama ng ating national territory. Because if you take a look at Article 1 of our Constitution, national territory, it says that our national territory comprises the Philippine archipelago and all territories over which it has sovereignty and or jurisdiction. Yung all other territories, it refers po, kasama po doon yung North Borneo. So hindi po siya kasama sa main archipelago natin, pero kasama po siya sa national territory natin under the Constitution. Ngayon, yung main archipelago natin, meron siyang archipelagic baselines at yung maritime zones natin nakaproject doon sa archipelagic baselines natin. What about yung North Borneo po? Yun po yung tanong ni Sen. Padilla. Yung North Borneo, hindi po archipelagic baseline yung gagamitin natin doon. Yung baseline po na
I'd like to recognize the arrival and presence of our minority leader, Senator Coco Pimentel Jr. Go ahead, Attorney Gancho.
Thank you po. Under UNCLOS po kasi, Mr. Chair, there are three kinds of baselines. Meron po tayong normal baseline, straight baseline, and archipelagic baselines. As an archipelagic state, gamit po natin yung archipelagic baselines for our archipelago. But dun po sa other territories natin, which include North Borneo, Kalayaan Island Group, and Bajo de Masinloc or Scarborough Shoal, yung baseline po nila for their maritime zones will be what is called normal baseline. Yung normal baseline po, it would follow the shape of the coast. So pwede pong pa-curve yung coast, yung pa-curve po yung coast, yung normal baseline niya, at doon ka po mag-project seaward ng maritime zone ng North Borneo. So the North Borneo would have its own territorial sea, contiguous zone, exclusive economic zone, and continental shelf. That's the answer to the question of Sen. Padilla. Thank you so much, Mr. Chair.
Dr. Padilla.
Apo, mahal na tagapangulo, siguraduhin lang po natin na lahat ng binanggit ng ating panauhin ay makita natin doon sa panukalang batas para makasigurado po tayo. Kasi dito masyado na po ako naging masaya kasi galing sa UNCLOS ito Nakita ko talaga nakalagay ito, disputed. Kaya magandang balita na po yon para sa mga kapatid niyo po sa Sulu. Maraming salamat po, Ginoong Tagapangulo.
Thank you, Senator Padilla. Perhaps we can ask Senator Pimentel if he has an introductory statement or interjection, if any.
None, Mr. Chairman. None. Thank you.
There was a raising of hand by a resource person virtually present. I think that's Professor Batumbakal. Nagtataas siya ng kamay kanina. Technical, can we have Attorney J. Batumbakal? Nagtataas daw ng kamay. Attorney Batumbakal, where are you now?
Yes, good morning.
You would like to answer a query or make an interjection?
Opo,
Sige po,
good
go ahead.
morning.
You have the floor. I will give you 5 minutes.
Sige po. Actually, sinasagot ko rin po yung query nyo habang pong nagsasalita po kayo kanina.
Asan po
ilang
kayo, sir?
tanong nyo
Nasaan po kayo ngayon?
Nasa Canada po ako ngayon. Mayroong
malayo,
conference
oo.
dito na nag-present po ako tungkol dito nga sa West Philippine Sea.
Yung katanungan ko ata tungkol doon sa kailangan pa bang kumonsulta tayo sa IMO bago tayo gumawa ng archipelagic sea lanes? Yun po ba yun?
Opo,
Pakisagot po,
tsaka
sige
yung
po.
mga questions sa air routes also. Ito pong issue na to actually, isa po to sa mga una kong pinag-aralan nung pang nag-master's degree ako noong 1997, kaya matagal na rin natin itong sinusubaybayan. Ilang taon na rin, ilang beses nagdaan itong panukalang archipelagic sea lane, no, sa iba-ibang proseso. So, yung pong binanggit po ni Professor Beckman, yun nga po yung proseso talaga. Mayroon pong tinatawag na guidelines for the designation of archipelagic sea lanes. Ito po ay isang IMO resolution. Ito po ay naging produkto nung initial na designation process na ginawa ng Indonesia noong 1996. Tayo po ay miyembro ng IMO. Malaki po ang role natin sa IMO kasi po yung mga seafarers, no, ng World Fleet. Ang pagkakaalam po ng marami ay 25% of the seafarers of the world are Filipino. Kaya medyo malaki po ang boses natin sa IMO. Yung pong issue ng designation ng archipelagic sea lane, hindi naman po ito magiging diminution ng ating sovereignty, hindi po ito nakakabawas sa ating sovereignty. Kumbaga ito po ay parte talaga ng ating interaction with the international community. Pareho lang din po ito sa pag nagpupunta tayo sa IMO para magkaroon ng mga pag-implement ng mga international standards sa seafaring, sa shipping, at iba pang bagay na nasa ilalim po ng IMO. Particular po itong designation ng sea lanes sa IMO na under po siya sa Maritime Safety Committee kasi primarily po yung safety ng navigation ang naging malaking kumbaga issue dyan sa designation. So yung pong pagkonsulta sa kanila actually ay isang magandang paraan para nga makita natin, una, kung nasan ba talaga itong mga routes used for international navigation. Kasi depende rin yan sa bansa kung nasan siya, kung anong ruta niya. Pangalawa, depende rin doon sa uri ng barko, kung saan siya dadaan. Meron pong mga ruta, for example, na gagamitin ng mga malalaking oil tanker, pero hindi yon yung magiging ruta ng mga mas maliliit na mga bulk carrier. Kasi depende po to dun sa maneuverability ng mga barko. Kaya talagang importante po na gawin itong consultation na to para nga mapalabas natin yung mga datos at impormasyon tungkol nga sa mga dinadaanan at kung anong dumadaan sa ating katubigan. Pangalawa pong dahilan ay sa pamagitan nitong consultation, magiging negotiation yon actually. Tinulungan ko na po ang DFA dati nung ginawa natin yung designation ng particularly sensitive sea area sa Tubataha Reef para naging internationally recognized na marine protected area yung Tubataha Reef kasi nga ilang beses na may nasasadsad lagi dun sa Tubataha. Ang dahilan kung bakit nasasadsad doon, hindi po siya designated internationally, wala pong mga measures para iwasan siya ng mga barko. So kailangan po na ang IMO mismo, daanan natin ang proseso ng IMO para talagang sundin nila yung gusto natin, which is lumayo sila sa Tubataha Reef. Kaya nag-successful naman po tayo noon, kaya ngayon iniiwasan na siya ng mga barko, nakamarka na talaga sa lahat ng international navigation charts na dapat umiwas sila sa Tubataha Reef. So parang ganun din po ito, ginagamit po natin yung mga international standards, yung mga international rules, no, para nga makuha natin yung tamang ruta nitong mga international shipping na ito. Yung po sa tanong nyo naman na yung paano po yung mga eroplano, yung mga air routes. Actually kasama po yan dahil sa UNCLOS po, yung archipelagic sea lane includes the waters and the air routes above, no? So kumbaga automatic po yan. Pero ito pong mga air routes na to actually ay para lamang dun sa mga barko na mayroong kumbaga nakasakay ng mga eroplano o kaya helicopter, etc. Usually mga military vessels ito, pero meron din mga scientific research vessels na mayroong mga ganong klase o kaya mga Even yung mga pinakamalalaking mga yate, minsan may mga helicopter na dala yan. So, yun po para makover yung kanilang pagdaan dito sa mga archipelagic sea lane. Kaya automatic po, sinasama po yung air routes. Pero, nakalagay din sa UNCLOS na pag ginamit yung mga air routes na yun, dapat susundin niya ang lahat ng existing rules for safety purposes ng International Civil Aviation Organization. Ito pong ICAO, yan po naman ang namamahala sa kalangitan, no, sa air, lahat ng air traffic. Yung pong sa air routes above archipelagic sea lanes, sa tingin po talaga ng madami, hindi naman po lahat ng eroplano gagamit nito kasi usually pag sea lane, medyo syempre paliko-liko yan dahil ang isinusundan nila ay yung tubig. Pero pag nasa ere ka, hindi mo kailangan gawin yon. So yung pong pagdaan ng mga eroplano, actually covered naman po yan ng separately ng tinatawag nating air law or aviation law. At yung pagdaan nila sa ating kalangitan ay laging covered ng isang air agreement. No? So iba naman po yun, yung safety concerns po natin doon, security concerns, ma-address naman po yan doon sa aviation law natin at aviation agreements. Kaya nandun po yung CAAP siguro kung nandyan po sa session hall. At iba pang mga agreements nga natin, yung mga air agreements natin with other countries. Yung pong mahalaga po talaga itong consultation process sa IMO, kaya nga po yung isa dun sa mga panukala na pinaboran namin matagal na, ayun nga pong bigyan ng authority na lang, i-delegate na lang ng Congress sa executive itong final step of identifying and designating sea lanes. Kasi po, yung sea lanes pwede pong magbago yan eh. Depende kasi yan sa kondisyon ng tubig. Kung magtatanong po tayo sa mga marino, iba-iba din ang ruta nila, depende sa panahon. Merong mga ruta na safe pag amihan pero hindi safe pag habagat, for example. At may mga ruta na ang pwede lang gumamit ay yung mga maliliit na barko pero hindi pwede yung mga tanker. So dahil po may mga iba-ibang kumbaga possible na routes yan, kailangan talagang i-consider yan at i-administer yan ng executive kasi magiging mas responsive, mas flexible sila kung kailangan. Imbis na bawat galaw ay pupunta po sa kailangan pang magpa-amend ng law, ito po pwede nang idaan dun sa mga normal safety functions naman ng Philippine Coast Guard at Marina siguro, dahil sila naman yung mayroong capacity at authority para nga i-manage itong maritime traffic. At isa pa, kasi nakakibat din dyan yung mga safety measures for purposes of navigation. Kailangan din po natin kumbaga i-maintain yon, mga aids to navigation doon sa mga lugar na yan. Kaya paminsan-minsan, kailangan siguro na pagdaanin ang mga barko sa ibang ruta habang inaayos natin yung isang ruta. Yun po yung tinatawag na substitution of sea lanes na allowed din po sa UNCLOS. So yung flexibility po na yun ay very important for purposes really of safety para ma-achieve po natin yung objective originally ng Pilipinas nung nag-propose sila na dapat may sea lanes. Kasi nga, ang takot po ng Pilipinas noon, nung pumasok tayo sa UNCLOS negotiation, parang wala tayong control sa kung saan nagpupunta yung mga barko na yan at pag kung magkakaroon ng aksidente or kung may gagawing masama, kunwari mga smuggling, hindi natin makontrol. So yun po yung talagang issue doon, yung safety and security of our waters, no? Vis-a-vis yung mga foreign vessels na nagdadaan. Pwede po yan ma-address nitong archipelagic sea lane, particularly pag military vessel po. Tapos the rest po, pwede naman through yung normal sea lanes na sa ngayon ginagawa na naman po ng Coast Guard.
Salamat, Attorney Batumbakal. I understand Dr. Stuart Kay of the Australian National Center on Ocean Resources and Security is now ready to log in or naka-log in na siya. Been trying to Comsec, Dr. Stewart, do you hear us?
Si Michael Caine.
We cannot hear you. You're muted.
Senator, I can hear you very clearly.
We can hear you. You're now in where are you now? Brisbane, Sydney, or
Wollongong, sir. Wollongong.
where?
Wollongong, just south of Sydney.
Okay. So I think you've been monitoring the discussions here. This is a special committee on Senate Special Committee on Maritime and Admiralty Zones. We would like to get your opinion as to the necessity of having our own Philippine Maritime Zone law. What would be its advantages, disadvantages, if any, and how would it affect the Philippines in its current tensions, quote unquote, with other claimant states? in the area. We're now talking of current news. So, Dr. Stewart, can you provide your input? I doubt if you were present when we required all the resource persons to take their oath.
I'm happy to take an oath if you wish,
Yes.
Senator. I'm more than
Yes.
happy to attest.
Yes, even from down under.
Yes.
No need from. Yes, there is an opinion here coming from our senior minority leader that you're not in Philippine soil, you're not inside the Philippine consulate or the embassy. So we'll just require you to answer if you wish. No compulsion whatsoever. How would you address those concerns which I just propounded?
Senator, I do think that legislation clarifying the Philippines' law of the sea practice would be helpful in the present circumstance. I say so in my own basis. I'm not speaking on behalf of the Australian government. I'm a private citizen and academic. But I think it would be a good thing. There are a number of reasons why, but chief among them is that the Philippines' responses to the present situation and responses to earlier situations that gave rise to the litigation that you pursued with the People's Republic of China, the famous arbitration, these were all based on the Philippines relying strongly and clearly and consistently on international law, and particularly the United Nations Convention on the Law of the Sea. Now, some of your legislation predates the implementation of the convention, and at times since the convention's entered into force, the Philippines has updated various aspects of its practice. But this has been done in small pieces, like your baselines update in 2009 with legislation that was adopted then. I think there are merits in pursuing legislation which deals with law of the sea matters as a whole and makes certain that the Philippines legislation is consistent with its objective to act consistently with the United Nations Convention on the Law of the Sea and be a good international citizen in complying with international law. That has served the Philippines very well to the present point in time. The successful prosecution of the case in the arbitration, the overwhelming legal victory that provided, testament to the value in this. That was initiated at a time when the Philippines was under great pressure with the resupply to Scarborough being made so difficult. And the arbitration has created a situation that has improved things over the last decade. It's true at present there are clashes taking place in the West Philippine Sea that are well documented in international media, but the Philippines' response has been to act in a manner, again, consistent with the law throughout. So it retains the support of the international community in responding to these difficulties. And that's very important because if you don't have a huge fleet to bring to bear and provide military support, you need the law to provide what support you can to ensure the international community see who is behaving correctly and who is not. And so legislation that reflects that, I think, is most important and will be of great value to the Philippines going forward as compliance with the law has been till now. Some of the aspects of your legislation that could benefit from this, I think I've been given access to a number of bills that have been brought before the Senate and before the House, and these have similar objectives as I can see. They're about ensuring that the interpretation of your law of the sea practice is linked and placed in lockstep with the Law of the Sea Convention, and that you will ensure that the rights under that convention are reflected in the rights that are asserted within your national legislation. And I think that's to be commended, and it's very valuable that can be done.
Professor, if I can make a slight interjection. One of the slides made a while ago by Attorney Silva has something to do with a 1988 Australian protest to a Philippine action. Can you refresh the minds of the committee members? What happened in 1988 that necessitated a reply coming from the Philippine government?
My recollection of that, sir, is that I think the Philippines had moved to ratify the Law of the Sea Convention and had issued a statement with respect to its understanding of how the convention would operate. And that referred to past practices, including the treaty limits box. And I think Australia expressed concern that that didn't reflect international law at that time. So that's my recollection of what that is about. It's my understanding that the Philippines practice today is based around your baselines law and the laws associated with that, and that it doesn't seek to rely upon the old treaty limits box. So I'm sure that Australia and the Philippines are very much in accord these days. And that's
we're in sync. Your Prime Minister just visited Manila a few days ago. So I think the reply of the Philippines has something to do with enacting legislation that would harmonize our domestic laws with the law of the sea. Correct?
And that is a response that I'm sure the Australian government would be entirely supportive of, based on the statements I saw made by your president and my Prime Minister in their meetings that have been reported over the last week.
Thank you, Dr. Stewart. Anything to add, Dr. Kay?
Only that there are a number of aspects of some of the bills that I would suggest could do with a little clarification. The Philippines has archipelagic baselines around its territory, as asserted in the 2009 Baselines Law, and that legislation is well found. The Philippines also makes claim to various island territories in the West Philippine Sea, with Scarborough and islands within the KIG. I think it's important that your national legislation reflect the fact that some of your islands are not inside your archipelagic baselines. And the legislation in the drafts that I've seen pass over this is a relatively minor matter, but it's important to note that the islands in the KIG and Scarborough would generate territorial seas and should have territorial sea baselines that are pursuant to the rules for such baselines in the convention. The draft bills mention this, but very much as an aside, and certainly not in the sections that refer to the definition of baselines. And that could be clarified. I don't think the legislation, the bills that have been provided are wrong, but it would be good if this was made a little clearer, to make it clear on what basis the Philippines was asserting territorial sea baselines around features outside of your main archipelago. Because the provisions with respect to archipelagic baselines that are in the draft legislation, the draft bills I've seen, deal with this very well. The only other matter I'd make is a number of the bills refer to the doctrine of reciprocity, and I would caution against its use in this context, and I'll give you a couple of reasons why. I can understand the motivation. It sounds quite persuasive that you should treat people as they treat you and respond accordingly. But the operation of reciprocity in a multilateral convention can be quite complicated, particularly in circumstances where you were trying to identify which vessels you were going to treat differently to those with whom you didn't have concerns about the manner in which they were treating your vessels. So, for example, if a faraway state, let's say Iceland, decided to close access to its territorial sea to Philippine vessels, your response would be to say, well, we'll do the same thing to Iceland vessels, and that would be an example of reciprocity. The danger with that is you create a tremendous amount of work for your good officials at the Department of Foreign Affairs, that they have to be aware of what each state is up to, and your colleagues at the Coast Guard have to be able to identify such a vessel when they find it. And will they respond if the vessel is flagged in Iceland, or will they look for the beneficial ownership of the vessel being Iceland? Is it got to be a government vessel? And these are all questions which the bills don't answer, and which would have to be the subject of some concern to ensure compliance with legislation. I think relying upon the law and applying the law appropriately without seeking to respond in terms of direct reciprocity is a simpler and more easily administered approach. And concerns about the practice of other states can be dealt with at a diplomatic level. And it may be that the legislation could indicate that such responses should be encouraged. But I'm not sure that reciprocity would necessarily be something that could be easily done. I understand the principle, and I understand the motivation very, very well. And I think that to that extent, wanting to respond to illegal behaviour as you would in a trade dispute is very tempting. But the Law of the Sea Convention operates at a large multilateral level where different levels of control and ownership might exist, as well as the vessel's flag, and that would be difficult to accomplish. And so I'd caution against it as a response. They'd be the observations I'd make with respect to the legislation. One other thing that I would add, which could be useful, is that the legislation touches very briefly on the right of the Philippines to regulate marine scientific research in waters under its jurisdiction in a manner consistent with the Law of the Sea Convention. The Law of the Sea Convention allows you in your exclusive economic zone to impose all sorts of conditions on anybody undertaking research in that zone, including the right to have access to the results of that research, to allow your nationals to be on board, to have your students, PhD students and your academics on board, involved in that research and build capacity. And it can be very useful if your legislation provides mechanisms to facilitate such approvals and to give your people the access to be able to benefit from that. Most countries in the Indo-Pacific haven't done so, but those that have been able to boost their efforts in terms of marine science capacity quite considerably. An example in the region is Papua New Guinea, which has such legislation and has been able to draw much from the research that's done by other states, including Japan and the United States, in the waters of its exclusive economic zone and even its archipelagic waters. And this is something the Philippines has the right to do, and this legislation may be an opportunity in which that could at least be considered, because it would be a benefit to the Philippines, I'm sure. It could also make it explicit and clear if somebody comes into your waters and is doing research without that permission, that the legislation makes it clear that a process has to be gone through, and if it has not, then the permission does not follow. And I know that there have been instances of research vessels in waters of the Philippines, including your exclusive economic zone and including the area of continental shelf on the Philippine Rise, and that these have been matters of public concern, as I understand. Legislation could help at least provide a legislative mechanism to deal with permissions of that nature. They'd be the observations I would make, and I'd
thank you,
hope that they would be useful.
Dr. Stuart Kay, thank you for providing your inputs. I know your if I'm not mistaken, you're with the Australian National Center on Ocean Resources and Security. Perhaps the Department of Justice and the DFA can submit position papers relative to those three items. One, the reciprocity words in the draft, the measures filed. Two, the right of the Philippines to inspect scientific research ships. And number two, what's number two again, Dr. K?
Or
The
clarifying
archipelagic baselines, the archipelagic baselines
the baselines.
of KIG.
Territorial
Yes.
sea baselines for
Yes.
islands outside your principal archipelago.
Yeah, so those three items, perhaps you can submit to this committee, including Attorney Silva, if you can provide us your legal inputs to this three items, written perhaps submitted to this committee, DOJ, DFA, and the group of Attorney Silva. Just one last query, Dr. K. Is there such a thing as Great Australian Bight in your country?
Absolutely, Senator. It's a
Why
very
is it
large
called-
geographical feature.
Why is it called Great? Why is it called?
Well, because it's very big.
No, expanded. Expanded means great expansion. Great
Yes, yes.
it encompasses a large area of water.
Yeah, look, we use the word great in Australia in the way the Americans use the word grand. So they have the Grand Canyon and Grand Central Station. We have the Great Western
Great.
Highway and the Great Australian Bight.
Because our friend here from the DFA is happy with another term. Yusek Vega, what's that?
Great Philippine Sea. If you'd like, we could call it Grand Philippine Sea.
Great West Philippine Sea. Greater West Philippine Sea.
Look, far be it from me to refashion the geography of the Philippines, but we've found the term "great" useful in all sorts of contexts, and you can find it sprinkled all over our continent.
The Great Reef, right? Barrier Reef. Yes.
Yes, absolutely.
Thank you for your inputs, Dr. Stuart K. Perhaps during the next hearing, if you have time, we can still engage you as one of the resource persons, especially after we receive the written legal opinions coming from the DOJ, the DFA, as well as the group of Attorney Silva. Thank you for your time, Professor Stuart K. Unless my colleagues here have questions, Senator Pimentel is still thinking. And Senator Pimentel, Senator Gatchalian? Yes.
For Professor K, but for Attorney Silva, just very basic questions, considering that this is a 101 hearing. Attorney Silva, I understand that we are member and participant of UNCLOS. Is that correct, Attorney Silva? And I also understand that since we are a member, we abide by the rules and the statements and provisions in UNCLOS as if it is part of our own laws. Is that a correct interpretation, Attorney Silva?
Insofar as the state at large is concerned, the answer would be yes, but yes with conditions, Your Honor.
Okay, but as far as the Philippines is concerned, we consider it as part of our own laws. This is a very basic question because I'm looking at the proposals, and the word UNCLOS in many of the proposals have been mentioned at least 10 times, no? And it's referred to in many of the terminologies in the law. Since we are already adhering to UNCLOS, why is there a need to come up with another law, domestic law, to define all of these terminologies? We're adhering to it anyways. We're a signatory to it anyways. In fact, we used it in our own case. So why is there a necessity to enact a domestic law? Is it not redundant?
Thank you very much, Your Honor. In fact, Your Honor, that it has been a big theoretical question for a while. But if I may, Your Honor, I respectfully submit, but subject to correction from the experts, especially Professor K and Dr. Batong Bakal, my superior, it is not redundant for three reasons, Your Honor. Number one is that while it is in fact the general rule that it is part of the law of the land, as noted by the Supreme Court in Abbas versus Comelec, when we signed on to UNCLOS, it was made conditional to a declaration that UNCLOS will not automatically amend our laws. Rather, we will do it ourselves. So while the general rule, Your Honor, is that the general rule is that treaties are equal to law, that is the doctrine of Abbas versus Comelec. Nonetheless, we carved out an exception when we signed on to UNCLOS. That was the declaration made by then Senator Tolentino, Your Honor. And also by the then Senator Tolentino, Arturo Tolentino, and then sorry, Your Honor, and they're also head of our delegation at UNCLOS in Jamaica, and also so we carved it out as an exception. So as a consequence, it's not automatic because we made it not automatic. In fact, the concurrence by the Batasang Pambansa basically incorporated by reference that declaration that it will not automatically amend it. Second reason why, Your Honor, it is not superfluous is that we have a lot of laws that are inconsistent with the new UNCLOS regime, and it is not entirely clear to what extent they were impliedly amended by Republic Act 9522. Because our interpretation of RA 9522, it amended a lot of these laws. But which of these laws it impliedly amended, because under the doctrine of laid out by the Supreme Court, there's an implied amendment when there's clear irreconcilability between the earlier law and the later law. But which of these are irreconcilable and impliedly amended is not clear. And if I may rattle off what are those laws. Number one, Republic Act 3046. Number two, Your Honor, Presidential Decree 1599, because its reckoning point for where the EEZ starts is from the baselines, which is no longer consistent with UNCLOS, which states that it should start from the outer edge of the territorial sea. Next, PD 1596 was impliedly amended but not expressly amended, hence clarity would be necessary. Next, Your Honors, Republic Act 7942 makes a definition of contiguous zone, which is unfortunately not entirely consistent with UNCLOS, because under UNCLOS, the contiguous zone is for law enforcement on customs, fiscal, immigration, and sanitary purposes, whereas the contiguous zone under the Mining Act is for mining. So it is not entirely in consonance with UNCLOS, and it is not clear which of these were impliedly amended. And I defer to the law enforcement agencies on this, but I think the law enforcement agencies would benefit from clarity as to which boundaries we are now following because of the implied amendment. Because an implied amendment, unfortunately, needs to be interpreted again. And the third reason, Your Honors, why it is not superfluous, although it should be, because if we had made it part of our land, law of the land, is that the language of UNCLOS does not categorically say that we have a territorial sea or that we have an EEZ. It states that the coastal state may establish a territorial sea up to 12 nautical miles, may establish a contiguous zone up to 24 nautical miles from the outer edge of the territorial sea, and may establish an EEZ up to 200 nautical miles, which we did in PD 1599, but with an inconsistent start. The only thing that's automatic is the continental shelf, which pertains to the coastal state subject to extension under Article 76. Hence, for this reason, it is also not superfluous. So three reasons. Number one, we made it an exception to the general rule that it automatically amends our laws. Number two, it is not clear which was impliedly amended by RA 9522. And from an administrative purpose, I think our law enforcement agencies would benefit from clarity. And number three, the UNCLOS says we have to establish it. And so it still pertains to us in our act of sovereignty to establish it through the Maritime Zones Act. But we submit, Your Honor, to the wisdom of the body and also to the real experts in the room, Your Honors, specifically Dr. K and Dr. Batong Bakal. Thank you, Your Honors.
Thank you for that, Attorney Silva. On the second reason on where it will clarify a lot of our own domestic laws in relation to UNCLOS. And you mentioned a few, no? Those laws that were impliedly amended or repealed throughout several laws that were enacted. Can you assist the committee and furnish us what are those laws? So we'll be guided that throughout the years we have already impliedly amended some of our laws, and it created inconsistency between our domestic laws and also UNCLOS.
Yes, sir.
It would be a great help for us to understand what are those laws and also have concrete examples.
Yes, Your Honor.
And lastly, Mr. Chair, with your indulgence, you mentioned earlier, you mentioned a statement that the arbitral ruling is the start of negotiation with China, no? And the negotiation can take 1 day, can take 1 century, no? So can you give us some examples in which countries have successfully negotiated using arbitral rulings, using UNCLOS, just probably later examples, no? If you can cite how this type of rulings or UNCLOS itself, no, has been used to successfully negotiate between two countries.
Your Honor, I can name 2 examples off the top of my head right now. One of them, however, I would defer to Professor Dr. K, because that is the Timor-Leste Australia negotiation, which was in fact a successful application to the conciliation provisions of the convention, under which they had a disagreement, considering the, I think the Sunrise gas field or oil field in the Timor Gap. And they negotiated. In fact, at some point, it was a subject of a case which was later withdrawn by Timor-Leste, and then a conciliation proceeding leading to a successful negotiation and a successful conclusion of a treaty for that case. That's example number 1, Your Honors. Number 2, Your Honors, is a successful conclusion of the Beagle Channel dispute. I think it's the Beagle Channel dispute between Argentina and Chile, and this was actually very apropos and very relevant to us, because what happened in this case was that there was a long-standing dispute over the Beagle Channel between Argentina and Chile. The Beagle Channel is an area near Tierra del Fuego. What happened was they had an arbitration case beginning in the 1960s. They gave the arbitration to the Queen of England, the late Queen Elizabeth II, who appointed a 5-man panel of arbitrators. They came out with an arbitral ruling, I think 1976, but it was rejected by Argentina. After it was rejected by Argentina, they began to negotiate, but Argentina insisted we must negotiate without the ruling, disregarding it. And Chile said, no, we must negotiate based on the ruling. They tried to appoint a joint committee of inquiry, it failed. And they almost went to war in 1978 December. It was only averted because of the successful intervention of, number 1, the Vatican nuncio in both capitals, and number 2, the U.S. ambassador, if I remember correctly. That was December 23 or 26, 1978. Thereafter, they gave it to me. So what happened was they asked the papacy's mediation, the Holy See's mediation. In 1982, they proposed a solution, and Argentina rejected it again. So what happened was Argentina went to war with the United Kingdom and lost in the Malvinas or Falklands armed conflict. And thereafter, a change happened in Argentina, and the new government was willing to negotiate now. And because the new government was willing to negotiate in good faith, they came up with a new conciliation proceeding in 1984, and thereafter a new agreement, the Treaty of Rome, in 1985. So this was a tortuous process involving mediation, an arbitration, and then treaty, and then a joint inquiry and a meeting, and finally a negotiation. But it has happened before, and one may hope that when the other country, especially the People's Republic, is willing to negotiate in good faith, it may happen to us again.
In that example, was the negotiation, was the arbitral ruling of that particular case used as a basis of their negotiation?
For the most part, if I recall correctly, but I'm sorry, I have to refer to the records. It's RIAA, the report of International Arbitral Awards, RIAA. Yes, but they modified a little bit. So it was basically the primary basis. So where Argentina formerly insisted on negotiating, but without regard for the award. But this time they negotiated in good faith on the basis of the award. And I understand there was some modification because that's part of the give and take of negotiation. And so they succeeded in 1985. Beagle Channel dispute.
Any negotiation, you have to compromise somewhere there, no? So, but I think the bottom line there is the basis of the negotiation, which is that ruling for that particular case.
Yes, Your Honor.
Yeah. Thank you, Mr. Chair.
Senator Gatchalian, is Senator Pimentel now ready to propound these questions? As per order of presentation, I think we still have, are we done with DFA? Okay na, DFA. So, from the academe, I think we're done with Attorney Espinella. You're with the same group as Attorney Silva. And then from my records here, the National Security Council, the National Security Group. But, ladies and gentlemen, you have to note that this is quite extensive for legislators like us. We're not claiming to be experts here, so it will be a process. So we will be guided. You will be guided. So I think it will take us 4 more hearings to really come up with an airtight maritime zone bill. So unless our colleagues here would propound other questions, I think we can suspend this. But Director, Professor Pauling, any final words? Again, I'd like to thank you for being with us here present. Yung mga iba sa susunod siguro, tatawagin namin kayo we will wait for the responses for the 3 queries coming from Director Stuart K. Professor Pauling, any final words that would probably jibe with the observations of Professor Stuart K, and perhaps reply again, though it may be redundant to the query of Senator Gatchalian. Why is this needed? Why should we really craft a maritime zone bill when UNCLOS is now part of the laws of the land? So why is this really that urgent for the Philippines to craft this piece of legislation, and including the probable progenies of this, the ASL, the other archipelagic zone bills, including perhaps the answer to the query of Senator Padilla before? Is there any urgent reason for the Philippine Senate to craft this?
Thank you, Senator. I would wholeheartedly agree with the legal points already made by Attorney Neil Silva. I would refer back to a point made in Attorney Neil's presentation early on about the value of this and any other legislation that clarifies Philippine claims and brings it into greater accord with UNCLOS in building the international coalition in support of Philippine claims and in support of the 2016 arbitration. To Senator Gatchalian's question about previous arbitrations and negotiations that have built off of arbitrations, moving away from UNCLOS for a moment, I would point out maybe a better analog would be from my own country. You know, in 1986, Nicaragua took the United States to the International Court of Justice. The U.S. stuck with it until the hearing on jurisdiction, at which point the ICJ found jurisdiction in favor of Nicaragua. The then Reagan administration walked away from the case, said that they would not comply with any ruling. The ruling came down. Without U.S. participation, Nicaragua won. This was in reference to U.S. support for the Contra rebels and mining of Nicaragua's harbors. Very similar to the process here in which China refused to take part in the arbitration. Nicaragua spent the next several years, into the mid-90s, building an international coalition to condemn the U.S. noncompliance, brought up resolution after resolution in the UN, which the U.S. lost by greater and greater margins every time, toward the end abandoned by even our closest allies like Palau, until eventually a new government in the United States, first George H.W. Bush and then President Clinton, slowly brought the U.S. into compliance with the award without ever admitting that that's what the U.S. was doing. And eventually, in order to save face, Nicaragua formally dropped the case after the U.S. had already come into compliance. This will be a long process, but it is entirely imaginable for me that a future Chinese government, probably years from now, in the face of overwhelming international pressure, will find a face-saving way to comply with the arbitration award without ever actually admitting that's what it's doing.
Totally agree. Is there any other example aside from that Nicaraguan case?
More recently, I would highlight the 2014 Itlos case in which Russia lost to the Netherlands. Russia had seized the Arctic Sunrise, a Greenpeace icebreaker full of protesters, flagged to the Netherlands. The Netherlands took Russia to Itlos, the International Tribunal on the Law of the Sea in Hamburg. Russia said it would never comply with any ruling from Itlos. But then after it lost, it released the icebreaker and said, well, we're doing it under our own domestic law, not because you told us to. Again,
That's President
faith-saving
Putin.
ways.
That's President Putin.
Yes, and so this is the way that, let's say, sensitive great powers often behave. They eventually comply because of the weight of international opinion, but they never admit that they're complying.
That's DFA.
Yes, I'd like to add another example.
Thank you, Professor
Thank you.
Pauling.
Of course, if I may segue about the Nicaragua thing, it did help that there was a new government as well in Nicaragua, Violeta Chamorro, in 1990, I believe it was. But then again, that's why there's elections. Anything could happen. Yes, there's another example, sir. The UK Mauritius dispute over the status of the Chagos Archipelago, which is a group of islands just adjacent to Mauritius, which the UK was using as some sort of a sanctuary for animals, I believe it was. And there was an award given recognizing Mauritius's claim over the Chagos Archipelago, and the UK and Mauritius are negotiating on the basis of such award. So it can work, sir. We will reaffirm our going to work with you. We already see, based on what Attorney Silva was saying, your definition of territorial sea in each of the bills is there may have been a typo. It says 12 nautical miles from the baselines of the territorial sea. So that's redundant. It's obviously baseline from the archipelagic baselines, so we'll work with you, sir. I'd just like to mention also, although Senator Padilla is not here, another way we are defending our sovereignty or claim over Sabah. There is a continental shelf submission of Malaysia before the UN Commission on the Limits of the Continental Shelf, which we have objected to, because part of it is measured from North Borneo, which we claim. So we've objected to it, and it's not yet been approved by the UN. You could compare that with our submission for the Benham Rice, which was approved, and Attorney Batong Bakal was one of those, was part of that process. So recourse to international law and international institutions works. And by passing these laws, we're strengthening our resolve to follow the dictates of international law and set the example for all claimants.
Thank you, Yusek. Thank you, Yusek. Before Senator Gatchalian, yes.
Mr. Chair, I just want to ask Professor Pauling something that is I read in the internet. I understand that the U.S. is not part of UNCLOS. Is that correct?
The United States is a signatory to the 1994 implementing agreement. The U.S. Senate has never ratified UNCLOS. The position of the U.S. government has been since the Clinton administration that UNCLOS is a matter of customary international law, and it binds the United States like it binds all countries. So the U.S. does comply, and I would flag the oft-quoted last president of the UN Conference on the Law of the Sea, Tommy Koh of Singapore, who would often say he would much prefer the U.S., who complies with the treaty without being a party, to China, which is a party but doesn't comply.
That's my, well, actually, I wanted to ask, how come the U.S. Is not part of UNCLOS? And what's the reasons for not being part of the UNCLOS?
I want to be careful talking about the deliberations of my own Senate in front of your Senate. Let me just say that U.S. objections originally in the 1980s were based on the provisions related to seabed mining. That's why we had a renegotiation that led to the 1994 implementing agreement. Since 1994, in my opinion, U.S. opposition has been largely ideological from some components of the U.S. body politic. But again, the U.S. executive has always maintained for 30 years now that UNCLOS is in effect, it binds the United States, and we will comply with it.
Without it being an official participant of UNCLOS, do you think it will diminish the moral ascendancy of the U.S. in trumpeting compliance to UNCLOS?
I think that it damages the United States rhetorically, and it gives China firepower to accuse the United States of hypocrisy. But I'd also argue that U.S. noncompliance, as my mother told me in kindergarten, two wrongs don't make a right. Whether or not the U.S. is party to the treaty has nothing to do with China's obligations to its neighbors.
Document does it? Is there any formal document that the executive issued saying that even though there's no ratification to UNCLOS, it will be compliance or it will comply to the provisions of UNCLOS? Is there any executive order or any formal document to that effect?
I think we could probably find hundreds of examples. Every time State Department issues new limits in the sea study, they make this point. Every time U.S. Department of Defense, the Secretary of the Navy, Department of State testifies on any issue related to maritime law, they make this point in the Congress. And it's never really been challenged in the United States. As far as the United States is concerned, UNCLOS applies to everybody, whether you've ratified the treaty or not.
Thank you for that. And lastly, Mr. Chair, I just want to ask Attorney Silva again. I understand from my team that this will be the first time that if ever these proposals will be approved, this will be the first time that a legal document will cite the arbitral ruling. If I understand it correct, this will be the first time. And what will be the effect of that? That the arbitral ruling now will be formally enshrined in a law duly approved by Congress and the Philippine government.
Thank you very much, Your Honors. This is something that would require a elucidation in a paper, but off the top of my head, I would say number one is that even without this bill, even without this law being made, the arbitral ruling is already binding as far as the Philippines, because as a signatory to UNCLOS and Pacta Sunt because of the principle of Pacta Sunt Servanda, we are required to comply in good faith with the treaty and with UNCLOS. And what happened with the arbitral award is that it basically interpreted the treaty to which we are bound. In fact, there is actually an express provision in the treaty and in UNCLOS in I think chapter 15 on dispute for settlement that the parties are bound by the award. So even without it, we are already bound, number one. And number two, even without it, because we are party to UNCLOS, we are already supposed to implement it. The difference this would make is basically twofold. Number one, from a legal standpoint, even though we are bound by it, this one would, as I was reminded by Dr. Batong Bakal via message of the Doctrine of Transformation. Under the Doctrine of Transformation, the very many details of the convention would be transformed into Philippine law through appropriate enabling legislation. The same would happen with the 2016 award, which should be incorporated into law through enabling legislation and made the subject of an IRR and later laws. And number two, that's on the legal side. On the diplomatic side, we may note that the arbitral award was actually in what lawyers would call a declaratory relief. It did not actually create actionable. It did not say parties submit damages, pay damages to the Philippines because you violated their rights. What it did, it clarified the rights and obligations of the parties, and then it is up to the parties to implement those rights and obligations, including, for example, by implementing our law and enforcing it throughout the REZ, but also by demanding damages from the People's Republic for the destruction. And so this is part of that implementation of the award because it was a declaratory relief interpreting our rights, and now this is part of the implementation of those rights as well. Thank you, Your Honors.
Thank you, Attorney Silva. Thank you.
Senator Gatchalian. So I guess we have tackled a lot for this initial classroom experience. It's just the start of the semester for this committee, the initial convening of this committee. As what Senator Pimentel, this is class 101 insofar as this committee is concerned. So next time we will have a submission of assignments. The DOJ, the 3 queries coming from Professor Stewart K. Plus, the committee would like to have the Department of Foreign Affairs as well as the Department of Justice to provide the committee with a PowerPoint or any visuals that would give us a comparative as to the maritime zones of ASEAN states plus China and Taiwan. I repeat, assignment number 1 for DOJ and DFA. Maritime zone laws of ASEAN states plus China and Taiwan. Assignment number 2, perhaps a comparative matrix of maritime zone laws of South China Sea claimant states. So this committee would have a chance to look at the overlaps and other discrepancies. We will have a hearing week after next week. Pero break na tayo na, no? Okay. Week after next week, upon consultation with the minority leader, so your assignment will be due week after next week. I think we have tackled a lot. Those who were not called to recite today, testify today, will have their day in court next week, next hearing. Tatawagin lahat kayo. You will your silence would not mean that your voice will not be relevant. You will be graded accordingly because this is now the budget season time so far as the government agencies are concerned. I think we have tackled a lot. Senator Pimentel, anything to add? Any closing statement on the part of Senator J.B. Ejercito?
No, Mr. Chair, thank you for this, and it's been very. It's a good first class indeed. No, we're here to listen first, no, and we look forward to the next hearings and the submission of the assignments that were given. Thank you, Mr. Chair.
Senator Ejercito. Senator Gatchalian, very active participant today. Any final statement, sir? So with that, I think we've covered a lot for the first hearing. We thank the resource persons here present for sharing your time. You will be called next time. Those coming from abroad, Professor Stuart K, Attorney Batumbaka, who is in Canada right now. We hope to have Professor who was that? Robert Beckman of the National University of Singapore next time. And then for Professor Gregory Polling from Princeton University, thank you for sharing your time, and the members of the Armed Forces of the Philippines here present. Maraming salamat po sa inyo. And without objection on the part of my colleagues here, this initial committee hearing of the Special Senate Committee on Maritime and Admiralty Zones is hereby suspended. Maraming salamat po.
Kaya mo, duha ka adlaw. Alala, sige. Boss, kamusta na boss?
Nangihingi?
Eh, lahat naman tayo. Lahat naman tayo, nangihingi talaga eh. Bingo.
Ay, akin na yung listahan ng Vice Chair, sponsors. Yung pinagawa kanina. Wow, yung sulat na to.
Si Ate Erling. Wala, maganda rin ako magsulat.
Sino magbabasa? Chairman dito, Comsec. Ikaw na, dito. Okay lang ako sa mama. Chairman niya. Karami kayo dito. Tandaan mo. Marami nga eh. 14 na.
Hindi naman. 14 dito.
Dami to.
Hindi.
1, 2, 3, 4, 5, 6, 7.
10. 10 lang.
Ganda na sulat. Readable. Readable.
Ayaw niya sa akin, hindi rito.
O yung list of, yung mga members.
Manifestation lang naman daw.
Pero naman hindi ka naman akin ba to kanina? No?
Di ba nga dito?
Si Alan hindi ko malikan.
Hindi na. Dati, sabi ko sa kanya, pumasok ka na.
Hindi nag-uusap na sila ba? Ngayon, kung sakali, papatapusin nila. Bago pag-motion.